before you make that conclusion.
No. I'm not making it. I'm just trying to clarify, ma'am.
No, you're clarifying wrong, because you must say it in the context of where you see his name. Tell me what I'm saying about his name.
In fact, it's for your own benefit, ma'am, so that in future...
No, Councillor. You cannot argue with the witness.
No, I'm just trying
She's trying to answer your question. You're putting a statement to her and she's answering and saying, no, this is not what I said. You have to read it in context.
Okay.
I think then you can take her to the context if you understand it otherwise.
No, we don't understand it. I just wanted to clarify it so that there's no criticism against her. In fact, in future, that she said all these things against General Poison because she had a bone to pick with General Poison. I'm just trying to clear the air in that regard.
Yes, but that's what she's answering. She said, yes. No, she had no bone to pick.
Okay, thank you, ma'am.
Remember, she is the witness for this panel.
That's what I'm trying to clarify.
We will protect her if you seek to cross-examine her in that fashion.
No, Madam Chair, I'm not trying to do that. I'm just
and when she answers you, pick it from the answer.
Yes.
Thank you.
Yes. Now, Ms. Noko, again, so that we're clear, I'm not sure whether you've got the Cock reports, report. Can you just pick one of them?
Yeah.
And turn to the last page, the second last page. I know that you've got two different versions, but the recommendations appear to be the conclusion part seems to be the same.
Yes, I see them.
Now, yesterday, Advocate Andrew said to you that when he was trying to advance the argument of a single prosecution authority, to say, in fact, Advocate, no, in fact, I'm trying to remember, just give me a second. When he said the Cock panel, in fact, withdrew the charges, the racketeering certificates. Do you recall that?
No, they did not.
No,
they didn't.
I never said that as well.
Yes.
Please.
In fact, I can't find it on my notes. That's what I wanted to quote him properly.
The racketeering authorization charges or certificate was withdrawn by Advocate Batoy.
Yes.
You remember even as the days when the withdrawal took place?
Yes.
I don't remember the panel of the Cock withdrawing anything.
No, I just wanted to clarify that so that it's not seen as if I wanted to check whether did we understand the evidence to be saying it was withdrawn by the Cock panel or was it by Advocate Batoy. But I do recall the chairperson clarifying that with her. I'll just move on from that point, Madam Chair. Thank you. Now, I just deal with the last part, which you spent a bit of time with Advocate Andrew on the...
Sorry, as regards the earlier point, I might have missed it. You referred to the recommendations of the Cock's report.
Yes.
Were you making a point on the recommendations?
The point I wanted to make was that the Cock panel did not withdraw. They simply recommended.
Oh, that's the same point.
Yes.
And you have corrected yourself now.
Yes. Now, the charges, which both the racketeering as well as the predicate charges, they've got a timeline. It's from 2008 and 2011. Am I correct?
Yes.
And one of the, insofar as the racketeering charges, one of the things you need to prove so that you must prove a pattern of racketeering activity.
Yes.
And it must be, you in this case, because of the number of accused people, you had to, depending on whether they are charged under management or participation, you had to ask yourself whether each one of them there's evidence of participation in racketeering patterns.
Obviously, when you charge people in any case docket, you check whether there's evidence to prove what offense against whoever, then you charge accordingly.
Yes.
Yes.
Now, we know that in this case there were at least 2 racketeering charges
Yeah.
against Poison, and then there were other predicate charges.
Yes, 5.
And we know that the predicate charges stem from, I would call, the Magojela incident.
Only the men, yeah, okay, all of them.
All of them.
Yeah,
So-
Makojela and Tembe.
That was one incident.
Yeah.
And he was not charged for any other incident.
I'm not sure if he was charged with the murder of Mr. Bongani Elfas Mkhize.
No, he was not.
As per the indictment, I don't have
No,
the
no.
indictment.
The only charge insofar as the predicate charges was the Makojela incident, which we know that it was defeating the ends of justice, murder, as well as possession of contravention of the Firearms Controls Act.
Yeah, times
So,
2.
yes. And we know that all those offenses stem from one incident.
Yes.
And other than that, there were no other charges that he faced on the predicate charges.
Okay.
Am I correct?
Yeah.
I'm asking this to so that I can find out from you as to what other evidence did you consider or do you rely on in substantiation of your point that there was at least a pattern of racketeering, demonstrated evidence of racketeering pattern against Major General Poison?
He was a manager.
Yes, I understand.
No, let me explain to you. He was a manager of this unit since it started. And the commissions of the dates for the commission of the offense is 2008 to 2011. He's been all along managing the activities of this enterprise. So it does not mean only because the 5 predicate offenses happened on the same day, which was 16 September 2008, it means he's not involved in the others. By association, he gets joined into. That is why also POCA legislation allows what would be misjoinder under ordinary cases. Where you join people together, you wouldn't ordinarily do that under normal circumstances, but under POCA you do that. So he's joined into that pattern of racketeering that happened for all those years. And by association, common purpose is also there. So the predicate offenses, it's only a requirement to charge with racketeering. It doesn't mean that he was not part of that pattern throughout those years.
Yes.
Yes.
And you're saying that his participation, his being part of those other offenses is through a common of doctrine purpose, right?
Yes.
But then the question is, why was he not charged with those other ones if he participated through the doctrine of common purpose?
That's how POCA works. You get joined in, not necessarily that you physically committed that, but by association, doctrine of common purpose, you are there as well. But it doesn't mean you were there, you committed, you did this. But because you are part of the enterprise, then you are also guilty of those as part of that is why you are prosecuted or charged together in the same case.
No, but I'm just asking, say, look, logically it would follow that you would have to be charged for the predicate charges as well because you participated through the doctrine of common purpose, or even on the predicate charges.
Yes, he was charged with predicate offenses. Maybe I'm not getting your question clear.
Yeah,
He was charged with predicate offenses, which are the prerequisites
But it was
for
one.
racketeering.
But it was one incident. The question I have is why, not in respect of everyone else, but only in respect of the Makojela case?
POCA doesn't say it must be 400 sins or incidents.
Okay,
As long as the requirement is that it must be 2 or more offenses, then they meet the requirements of being predicate offenses. And once you have 2 or more predicate offenses, then you have met the requirement to charge in terms of section 21E or 21F.
I just wanted to clarify that. Thank you, Madam Chair. Yes. Let me just confirm with my team whether I've got if there's anything I've missed. Oh, Madam Noko, I was just been reminded to just ask you to turn to page 70 of the DECOC report.
70.
Yes, bottom page 70.
Okay. I see it.
Page 70 or paragraph 70?
Page 70, Madam Chair. Are you there?
Or the pages are at the bottom?
Yes. Yesterday, you agreed with Advocate Andrew Chauke when he criticized through you the DECOC panel for not having gone in depth in the analysis of the dockets. Do you recall that?
Yes.
Now, I just want to check whether you still agree with his contention if you start under paragraph D from page 1, from paragraph 191.
Okay.
And where you would see, if you go through it up to page 91, if you go through that, you would realize that the DECOC panel, in fact, did analyze the case dockets, and they tell us what they are about. Do you
Which
see that?
paragraph are you referring
From
to?
191 to
Page 70? Is it
paragraph 191.
191 up to?
It goes all the way to paragraph 229.7.
I feel it's very superficial and I don't even believe it.
No, but
Because
the
they
point.
should be saying exactly
Please
what
allow
each
the
docket.
witness to answer
Okay,
you.
thank you.
You don't have to interrupt anybody.
Okay. I'm just saying that, in fact, the statement put to you by Advocate Andrew Chauke, which you agreed with, was that, in fact, they had failed to analyze each docket like you did. All they did was just to do to provide a laundry list.
No. The issue was that there are some dockets that are missing where there are no explanations or analysis on. And if you are referring me to paragraph D up to 191 up until where you're referring to, I will still say it's very superficial. You cannot be relying on this to make a decision. For you to make a decision, you must go thoroughly into each and every case, analyze it. Then you will be able to know, with a fine-tooth comb. Fine-tooth comb, yes. You must go through that and be sure that So this is a very superficial analysis that one cannot rely on to make a decision. More information was needed to know about these cases, to make a decision to withdraw the racketeering charges and all other charges, predicate and the rest.
Okay, I've got no further questions.
So it was on that basis that we're saying they did not read the dockets.
Okay, thanks for the clarification, Madam Noko. Thank you.
Thank
I've
you.
got no further questions, Madam Chair.
You also look at paragraph 191, the one that you've just referred us to. Just that paragraph. Look at the words in emphasis. Those underlined words emphasizing that there was no shred of evidence linking them to any offense. In the next line, it says they also allege that the accused also killed civilians and
One looks at it, there appears to have been some analysis of the dockets.
Yeah.
I'm not saying that the conclusions drawn are correct or not. And insofar as the question of whether there was tangible evidence or not, ultimately that is the question for the panel to answer, because that is what Advocate Chauke is accused of doing, that he made some of these decisions where there was no evidence. And I think at this stage, Madam Chair, I wouldn't want to be seen to be.
yes, but you are an evidence leader. You know these records better than us, as you presented the evidence in chief. Now, I'm asking you that now that these reports are not even giving us the summaries of the dockets, you remember Advocate Baltoi said she didn't read the dockets at all. She relied on these reports. Do you remember?
I recall that, Madam Chair.
Now, this very report upon which he relied do not even give us a summary or summaries of any of those dockets so that we can have a sense of whether the contents of the dockets were considered to make a determination whether there was a case, prima facie case or not. So without that, and somebody comes and say, from the look of this report, which does not even summarize, not even in one line, just simply giving us a broader picture without summaries of those dockets, upon which Advocate Batoi herself said, I didn't read the dockets. I relied on the DeCock report. But the report does not give anything insofar as each one of those cases, the 23 dockets, are concerned. And I'm asking you, as you lead, and that will help us, because the terms of reference suggest that there was no evidence.
Madam Chair, can I get? Sorry. Okay.
No, wait a minute. This very question comes from the very paragraph you drew our attention to. And I'm saying to you, as we ultimately have to decide that point, and of course you will argue it, but now that you raised it, I'm asking you, could it ever be correct, now having even looked at the summaries, that you don't take issues with? And we know that the report that was relied upon does not even give summaries. They emphasized words without shreds of evidence linking them to any offense. What do you make of that?
Madam Chair, can I confer with my leader before I make that concession?
Yes, if you can't assist me, it's fine. I understand.
I do not want to be seen to be not willing to make a concession when I have to, but given the fact that there are still going to be witnesses that will still come to and talk to the report.
You may confer with your colleagues.
Yes.
I thought that if you will be able to help us because you raised the point.
Madam Chair, the guidance I get from my team is that whether the reasons are sufficient or not, it's for the panel to decide. But what we have is, when you read from paragraph 191, yes, emphasis is made that there was no tangible evidence whatsoever, and they give reasons why they believe so, and from paragraph 192, 191, 193 downwards. And on those bases, that's what Advocate Batoy says she relied upon. And I think it's something that we can, with the panel's leave, should be considered against the totality of the evidence of all the witnesses that would still come. And then that's the question that I'll gladly answer during argument, whether after the evidence has been laid. But if Chair can pinpoint me, then I will answer that question at that point.
We know that we have to write to make a recommendation and an assessment eventually, but I raised it because you referred us to it.
I appreciate that, Madam Chair, and it's something that I'll ponder on moving forward, knowing that I owe the panel an answer, a simple, straight answer on that.
May I comment, Chair?
Wait a minute, commenting on what?
On the very same issue, if I may.
Which issue, Madam Noko?
The very same issue in paragraph 191. What my view is with this underlined writing.
Well, I just wanted counsel to assist me because they are leading the evidence, and he raised the paragraphs. So I'm not sure whether you really want to go there.
Ms. Noko is a witness, Madam Chair.
Should she do?
No, she's a witness.
I think you can do that.
Thank you, Chair. I just wanted to say this actually proves that they did not read the dockets, because anyone who read the docket wouldn't say there was no shred of evidence, wouldn't say there was no tangible evidence, with all the evidence that is full in that case.
You got it, Advocate Mchene.
That's Advocate Noko's conclusions, Madam Chair. I'll still give my submission later on. So I think, Madam Chair, that from our side, that's all. Unless the panel's got more questions for Advocate Noko,
yes,
then she may be released.
Yes, thank you, Advocate Mchene. My sister reminds me actually, our researchers noted the matters outstanding that were to be looked into, including the withdrawal of the predicate offenses by Advocate Harrison. Did you find that information, Advocate Lekgeto?
No, Madam Chair, I'm informed that the dockets will have...
You may speak into the mic, please. Please.
I'm informed by NPA that the dockets themselves will have the inscription by the prosecutors for withdrawal of respective dockets. And Advocate Zungu.
Advocate Harrison now.
Oh, thank you. Yes. She has written a report to the NDPP. They were looking for it, and they will make it available.
Which would tell us about the withdrawal of the predicate offenses.
Most probably because they say she indicates what happened in each docket.
Yes, please don't forget.
Yes.
Another matter pertains to the list of accused persons and their numbers. You remember during cross-examination this issue arose and the list was to be compiled.
I think it was for Advocate Moipone, Madam Chair.
Yes. Advocate Moipone.
Can I provide that tomorrow on Monday, Madam Chair? Because I must have missed that, but if the chair wants, the numbers, does the contact numbers or just the charges?
No, not contact numbers. Advocate Moipone, you are here this morning, please. You remember the cases in respect of the accused persons?
Yes.
Spoke about that. So if you can give us a list of those accused persons and their numbers.
The
case numbers.
So meaning the dockets under which they were charged, etc. That can I provide? I'll provide. I'll put that information.
I have to go back to my exact notes as regards precisely what you said we should do.
Remember, there is somewhere where they are listed as accused 1, 2, and we couldn't identify actually who is accused 3, accused 5, and if memory serves me right, accused 6 was skipped. We need to know what happened. Accused 12, and from accused 17 to accused 20-something, there were gaps. So that is the list that we would like to have. If somebody is deceased, it should be accused number so deceased, and then we will know so that we can cross-reference whenever accused are mentioned.
Okay, we'll do so, Madam.
Maybe to help you, the transcript will be available soon. You can go to the transcript and just check precisely what we want you to do in relation to that issue. So the transcript will pick it up and provide that list on Monday.
We'll do so, Madam Chair.
Not tomorrow. Tomorrow is Saturday. You can file it and we will have a look at it on Monday. Don't forget, please.
Thank you.
Yeah, Advocate Noko, there's a question that Advocate Moipone asked about charging the persons that were suspected of having committed the relevant offences.
Yes.
And the focus of that question was about the fact that General Boysen was the manager, right?
Yes.
the manager, in terms of your assessment, he was seen to be the manager of the entire enterprise.
Yes.
Right. Now, the question that he asked, and I don't think I got the answer, or I understood the answer that you gave, and I'm asking it again just in order to understand clearly what your answer is.
Yes.
Now, the question was that regard being heard to the fact that General Boysens was the manager,
Yes.
how come that he was not charged in respect of all the offenses with the others? Regard being heard to the fact that, I mean, it is on record that Boysens was the manager. Even at the time when Ayer was on the seat, he was on the seat but not on the operations. He remained the de facto manager of the enterprise.
I'm not sure how to answer this. He was charged with being a manager, 21F, and 21E being participating. So that participation relates to all other offences. But then the requirements for racketeering, for predicate offences, relates to the other 5, count 8 to 12. So he was not charged for, say, count 21 somewhere in the indictment per se, but he's part of the whole thing. Like he's part. I don't know how to explain it. Yeah.
Yeah.
But
yeah. Maybe let me say.
Yeah.
I understand. I think everyone that has been sitting here understands that.
Yes.
Looking at the evidence presented thus far,
Yes.
he was part of this enterprise.
Yes.
Right? But then the question just relates to regard being heard to that.
Yes.
Be it in predicate offences or even in the racketeering itself. Why is it that he is not the common co-accused in all the cases? I think if I understood what he sought to get was that, and if I'm wrong, nevertheless, I would like to know and understand.
I get
you.
the question now.
Yes.
Thank you, ma'am. Count 2, section 21A, covers that he participated in the commission of the offences, in the racketeering. So count 2, the racketeering one, covers that because he participated. The title of the charge is participating in the illegal activities. So it's covered there. So you don't necessarily charge him with possession of a licensed firearm in another there. You just concentrate on the requirements of racketeering. It's possible to charge a person only with being a manager, as long as then the predicate offences are there, 2 or more. But then with regards to Major General Boysen, it's not only being a manager, but also participating. So that participation relates to all other offences without him necessarily appearing in every count. It's covered under participation.
Right. Thank you. I think you've clarified.
Thank you, ma'am.
Advocate Mchene, that brings us to the end with this witness.
Indeed, so, Madam Chair.
Advocate Nkabinde, you have had your bite. Yes, thank you. Advocate Noko, we, the panel, take this opportunity to thank you for having made time, 3 days, to come and testify at our instance.
Yes.
We thank you and would like to excuse you so that you can travel to wherever you're traveling safely before dark.
Yes, Chair.
Once again, thank you. We wish you well.
Yes, I would also like to thank the panel the Enquiry for giving me an opportunity to come and assist them as well, and also making my stay here secure. I thank you.
We thank
And
you. You are
everyone.
excused, madam.
Thank you.
We have some other business to deal with as you leave.
Madam Chair, I just wanted to indicate regarding what the panel also raised in relation to the outstanding issues.
Yes.
The MEC's affidavit. It has been reported to us that I think the NPA team has difficulty finding that affidavit. Remember the MEC's affidavit in relation to the Mkhize case. I just wanted to say, because that might be relevant to this witness while she is being excused. I'm not sure.
I'm not sure. The witness just left now. Yes, I remember that that affidavit of the second respondent in the Mkhize application, that interdictory application by Mr. Mkhize. Well, if it cannot be found, it cannot be found, I suppose. If it can be found later, I don't think the witness can say anything about it, because those are the questions that arose from us. I wanted to see what was referred to in that paragraph by I think General Boysons, referring to that affidavit. But let's leave it there. If you cannot find it, you can only do so much. We will make a note. Thank you, Council. We'll leave it at that. And the matters that you raised this morning in chambers, was it for a private meeting or you'd like to raise it here? But before we get there, you owe us a report as regards what you were going to do when we postponed a matter a week ago regarding whether a conflict of interest has arisen. And I reminded you yesterday, Advocate Skosana, that remember, your witness is still under oath, under cross-examination. We have not been told by you as to what we are to do or to make of the fact that that witness has not come back. When is she coming back, if she comes back? How far are you with your intended approach to the minister regarding that purported conflict of interest?
Yeah, Madam Chair, the report I have is as follows, that that issue has to some extent been resolved, and I've been informed by the NPA team that she has now been granted permission to appoint a legal team, shall I say an attorney, who will then appoint counsel for her to assist her in relation to the legal counsel that she requires. And that has only occurred, I think, yesterday, so it was reported to me. And I am not sure whether that counsel has now been formally appointed. And I discussed it with Advocate Hali earlier on, and when we actually thought it will be part of our report in chambers, where he will also participate in giving that report, the finer details of what is happening.
Suppose you were advised by Advocate your attorney, the state attorney.
The state attorney.
The state attorney.
I was advised by my state attorney, yes.
Shouldn't you get further instructions from the state attorney? Mr. Semele Meja is here. As to, we need to get details because we have to move forward. It's not enough to be told that he has now been afforded an opportunity to be assisted. Then the question arises, what then? Because we are still waiting. Somebody must tell us when she's going to come and take the seat, the witness seat. When will that be, if he intends to come back? Will we know when? Mr. Semelemej, you are the state attorney.
Chair, I was informed by the head of the office, Mr. Chauke, yesterday night that the NPA ESCO has since taken a decision to afford the former NDPP with a legal team of her choice. So what is going to transpire is, because I'm the attorney for the evident leaders, there's an attorney, Mr. Matuba, for the NPA. So he's the one who's going to appoint a private attorney, who in turn is going to appoint a counsel of Advocate Batoi's choice. So I'm not sure if that process has been finalized of date. I'm not involved in that process. I was just informed because I had to update the evident leaders. Yes.
May we request you, and I'm sure I'm speaking on behalf of my sisters, let me just confer with we request that you request Mr. Mtuba to be here on Monday, 8:45, and give us a report. A full report, because we need to know when we should expect this witness to come back and testify.
Thank you, Chair. I'll do so.
Yes, thank you. Another matter that you were to raise in chambers, Mr. Skosana, was it the matter for chambers deliberations, or you want to raise it here?
Would prefer to raise it in chambers, Madam Chair.
I hope it's not a matter that is going to detain us for the better part of this afternoon, especially because we don't even have an idea what it is.
We think not.
And all councils will come to chambers hereafter, and we will listen to you. Tell us about the process. We postpone this matter to Monday. What is happening on Monday?
Well, Madam Chair would suggest, subject to the panel's will, to stand it down, for us to have that discussion, which we hope it won't take long, and then the way forward will be.
And
charted.
come back.
Indeed.
Yes, thank you. We'll adjourn for a few minutes and reconvene. Good afternoon, everyone. Good afternoon, Dr. Chauke. Dr. Mohlamayane.
Good afternoon, Madam Chair and your two sisters. I'm placing myself on record. I've not been active in the proceedings for the past few days. As discussed in chambers, Madam Chair, I wish to place on record as evidence leaders that we have no witness or witnesses available on Monday for reasons that have already been put forward. We need not go into details as far as that is concerned, but we have experienced challenges and difficulties in securing some of those witnesses. We are therefore not in a position to proceed on Monday, Madam Chair, and we humbly request an indulgence to be granted a postponement to Wednesday, the 11th of February, 2026. Thank you, Madam Chair.
Before we hear from Advocate Advocate Mohlamayane, it is not clear to us why we were approached only today about the possible postponement. Secondly, you are all aware of the fact that if you wish to postpone or to seek any indulgence, you have to apply. I have not been told why you have not applied to seek a postponement, so that you can get all the reasons that you wish to put forward as a basis for the postponement. You know our attitude already, that we are disturbed by the fact that we seem not to be making progress. This matter was postponed several times at your instance as evidence leaders because of the problems that you say you are encountering. And we impressed upon you last time that when you seek to apply, Dr. Skosana, you came here and made an application from the bar for a postponement, as you are doing today, now, without a full explanation as to why you seek the indulgence. We do not take kind to that. It makes it even more difficult, I suppose, for your opponent or for Advocate Gwentovi's team to consider whether to oppose or not to oppose, because he doesn't have reasons in writing that he can consider. So we are really unhappy that you approach these matters not once, but again and again in the same fashion. Let me hear from my sisters if they have any question. You have informed us in chambers, I must place it on record, that you sought to explain that some of the witnesses are not cooperating. Some of the witnesses are not ready to come, and that some of the witnesses may want to be called by Advocate Chauke. But I think it is proper that, and I'm saying this as our preliminary view, that you should be placing an application before us. I will hear whether Advocate Nkabinde, let us hear whether he's opposed to the request, then we can take it from there. Advocate Nkabinde.
Madam Chair, yes, Mr. Chauke opposes any application for a postponement, but he agrees that the correct procedure is that there should be a formal application. And if the matter stands down to Monday to bring that formal application, he is not opposed to that.
I beg your pardon, the latter part?
If the matter stands down to Monday to enable the evidence leaders to bring a formal application, then he will not be opposed. But the current application that is being pursued is opposed.
That event, Advocate Mutlamunyani, all of you understand how the Asian court works.
We do, Madam Chair.
If we are to place you on terms to file that substantive application for a postponement by tomorrow noon, 12 o'clock tomorrow, you file it of record tomorrow, that should be possible.
May I confer with my colleagues with your permission, Madam Chair? My learned colleagues are requesting that the latest be 1400 hours.
No. You start working on that application when you step out of here, because you already know the reasons. Remember, Advocate Chauke's team must respond to that application. And we are inclined to afford them an opportunity to file their answering affidavit by noon on Sunday. And if a need arises for you to file a reply, you will file it in the evening on Sunday. Evening, anytime before 12 o'clock midnight, so that by Monday morning, this application can be argued. I don't think you need written submissions. You can argue from the bar on Monday morning.
That will be in order, Madam Chair.
Remember, you are seeking an indulgence, which I'm sure you knew about it even by yesterday or day before yesterday. When we started with witness Advocate Noko, by that time you ought to have known who will be next. But when you come today, last minute again, like last time, without even explaining why only today, we will have to place you on very strict terms to file your application by tomorrow, by noon. Advocate Chauke will file his answering affidavit by noon on Sunday. And your reply will be filed on Sunday before midnight.
If so advised, if there's a need.
There's an
Madam Chair.
urgent application, isn't it?
It is, Madam Chair.
We cannot wait until Monday. And on Monday, you will then argue this postponement application. Might I hear from Advocate Nkabinde about the terms? We are of the view that you should be able to file your answering affidavit by Sunday noon, 12 o'clock.
Yes, I'm sure I have enough resources. We will file it. Yes.
We appreciate that.
Thank you.
And the evidence leading team, you have much resources. You have the state attorney on your side. You have the junior counsels who can assist with that. It's not a huge kind of an application, substantive as it should be, or is. It should be done. You already have your reasons that you mentioned in chambers, so that should not take time. And please adhere to these time frames, because if you delay, it's going to make it difficult for the Chauke team, Advocate Chauke's team, to answer on time. Let me confer with my sister. Yes, thank you. Take the following order. This matter is postponed to Monday. What's the date of Monday? 9. Yes, thank you. To Monday, the 9th of February, 2026 at 9 o'clock. Two, the evidence leading team will file an application for a postponement, as they indicate, by tomorrow, which is what? Saturday, the 7th of February, 2026. On at or by noon, 12 o'clock. Advocate Chauke will then file his answering affidavit on the 8th by noon of Sunday, that is by 12 o'clock. The evidence leading team, if so minded, will file their replying affidavit before midnight on Sunday, the 8th of February 2026. This application will be argued on Monday, the 9th at 9 o'clock. We so order.
As it pleases the Chair.
We adjourn until Monday, the 9th of February.